May I now request the next panel consisting of Senior Advocate Shri Godbole and chaired by Honorable Justice Shri Sandeep Marne to kindly come and take the dais. Ladies and gentlemen, with a round of applause. Thank you so much, Lordship. Thank you, sir. Honorable Justice Marne needs little introduction to the legal fraternity. Enrolled as an advocate in 1992, his Lordship built a distinguished practice before the Bombay High Court, specialized in service law, constitutional law, and commercial matters. He was designated as a senior advocate before being elevated as a judge of Bombay High Court. Known for his clarity of thoughts, meticulous approach, and deep understanding of law, his Lordship has contributed significantly to the development of jurisprudence across diverse fields. His keen interest in effective dispute resolution and administrative justice makes him uniquely placed to share his insight on evolving landscape of mediation in India. It is our privilege and honor to welcome Justice Sandeep Marne to this session. One thing which is not concerning mediation, but which is his love for wildlife photography, I couldn't really miss out on that aspect. That actually brings him and makes him the most ideal person to figure out and pinpoint at the baरीक and very minute delicacies. Chairing with him is Shri Godbole, who has an equally unique interest in wildlife photography, as I could get from one of the sessions with both of them. Shri Godbole, senior advocate, is India's most respected voice in arbitration and mediation. He is a distinguished senior advocate with decades of experience. He has practiced extensively in commercial, civil, constitutional matters and has made significant contributions to the development of alternate dispute resolutions in India. He is widely recognized for his expertise as arbitrator, mediator, and legal educator. It is our privilege to have Shri Godbole, senior advocate, to this distinguished panel. May I now just, 1 second, I'm sorry. May I just request Kanchan Pawar and Vaishnavi to kindly come forward and felicitate Honorable Justice Marne and Shri Godbole. Okay. May I request Shri Valavalkar to also join us for felicitation of Shri Godbole, along with a memento and a bouquet. Cutting my further speech short, I will now request the chair to kindly commence the session. So,
good afternoon all. I firstly congratulate the whole team of AAWI for organizing this intensive workshop. I was wondering why this is called an intensive workshop. But I can see the intensity with which all the organization and all the arrangements are made and the efforts that the whole team has taken, not just the office bearers, but I can see several members of AVI being involved in organizing this workshop for the lawyers. And I truly congratulate all of them that they have been able to organize this wonderful event. And the discussion that is happening over the last 2 years is definitely going to be an enriching experience for all of you. So usually it is said that wise men and women should not enter into a court. शहाण्याने कोर्टाची पायरी चढू नये किंवा उत्साहाचा मॅटर सेटल कर दो. So these colloquial phrases have in them roots for mediation and conciliation and settlement. So while we use these phrases quite often, but the idea behind that is that an effort should be made to settle the core disputes amongst the parties outside the formal court environment, because as all of you know, courts do take a lot of time to ultimately have a final verdict in a particular case. I also remember a very famous Bollywood dialogue, कभी कभी जीतने के लिए कुछ हारना पड़ता है. So this famous dialogue from Bollywood film Bazigar has a deep-rooted thought in the context of a dispute resolution mechanism. Sometimes both parties can have different interests, and something which is not of much value to one party can be of a particularly good value to the other side. A win for other party doesn't mean a loss to the other in every case. There can be win-win situations also. Understanding what the other party values more can help you maximize the value for both. A litigation may determine the winner and the loser, but a mediation often produces a solution in which interest, relationship, and future cooperations are preserved. With over 5 crore cases pending in Indian courts, there is now a greater need felt to have alternate dispute resolution mechanism. The Arbitration and Conciliation Act 1940, which got replaced in 1996, has provided some solace to this alternate dispute resolution mechanism. But as all of you know, arbitration ultimately lands in the court, both in terms of challenging the awards. In fact, in many cases, arbitration doesn't start unless you go to court. You file Section 11 application, then you need to file Section 9 proceedings, then there is a remedy of appeal. So I don't know the exact percentage, but there is a large tendency where the arbitral disputes finally end up in the court for final adjudication. So arbitration, of course, is also quite expensive. In India, it is largely restricted to commercial disputes only. So now a need is felt on a greater degree. In fact, one of your office bearers said to me in the green room that let us hope that the pressure on the court reduces. I said that let it reduce in my tenure. So it is therefore necessary to create an environment where parties do not need to approach the court at all and have their disputes settled outside a formal court environment. As of now, the mediation in India is largely unregulated and is more an informal way of exploring the possibility of parties resolving their disputes. The only statutory regulation for mediation as of now, as you all know, is in the Section 89 of CPC. Then you have Section 12 capital A of Commercial Courts Act. There is also provision under Section 30 of the Arbitration Act where arbitrator can also explore the possibility of mediation or settlement. But beside these three broad statutory provisions, there may be in Industrial Disputes Act, there is a provision for conciliation. But beyond this, there is no statutory framework in India as of now for enforcing a mediation in a formal manner. Mediation is not merely an alternative to litigation. It represents a different approach to dispute resolution, from confrontation to conversation and from adjudication to consensual resolution. In the previous session, part of which I have also attended, all of you have already been enlightened about the means of conducting the mediation. Both Justice Bharati Dangre as well as the experienced mediators, Ms. Mehta and Mr. Deshmukh, and Judge Jaiswal, who's himself a trainer, have already enlightened you on these aspects. So topic that is given to us for discussion on this panel is about the Mediation Act. And it said Mediation Act 2023, way forward. While it is easy for all of you maybe to go through quickly the Mediation Act, and I don't propose to take you through all of the provisions as such, but broad 7-8 provisions which are of material importance and which bring about some change in the mediation environment. We'll only have a brief discussion about that considering the time constraint we have. So Mediation Act basically is also an outcome of some judicial overreach, I must say. It all began, as you know, from Salem Advocates Bar Association and AFCONS, where the importance of Section 89 of CPC was highlighted by the Apex Court. Then in K. Srinivasa Rao, the Supreme Court emphasized the importance of mediation in matrimonial matters. And finally, in M.R. Krishnamurthy versus New India Insurance Company, the Apex Court finally highlighted a need for having a formal statute to govern the mediation in India. And the Mediation Act 2023 is ultimately a legislative culmination of a long judicial movement towards institutional and consensual dispute resolution. As all of you know, mediation is a process where disputing parties attempt to reach amicable settlement with assistance of a neutral third person who is a mediator who does not have authority to impose settlement on parties. And this is the broad definition of mediation under Section 3H of the Mediation Act. Thus, the essence of mediation, therefore, is both party autonomy as well as self-determination. Section 2 of the Mediation Act makes the Act applicable to all parties who reside or do business in India. It also applies to international mediations. It also applies to commercial disputes where government can be a party. So legislation accommodates domestic as well as some part of international, and most importantly, the government commercial disputes. A vital change has been brought out by the Mediation Act in the form of Section 4, which now provides for a mediation agreement. So like an arbitration agreement, now you can have a mediation agreement whenever you enter into a particular transaction. Section 5 of the Mediation Act deals with pre-litigation mediation, where it provides, and this is a debate going on as of now, because Section 4 as of now says that the pre-litigation mediation is voluntary. Even if there is a mediation, because the section itself says whether there exists a mediation agreement or not, parties can voluntarily and by mutual consent attempt to resolve their disputes before they go for a formal institution of a suit or proceedings. The only provision is in the form of subsection 6, which deals with motor accident claims, and where the settlement under section 149 fails, then it is mandatory for the judge to refer the parties to mediation. This is what happens under 4.6, but maybe there can be discussion on this, whether there should be, and Justice Dangre did voice it, that there can be a provision for compulsory mediation like under section 12A of the Commercial Courts Act. Section 6 provides for disputes or matters which are not fit for mediation. So everything cannot be mediated. So prosecution for criminal offenses, matters dealing with minors, or matters dealing with rights in rem like probate or say existence of intellectual rights. These matters cannot be mediated. But the proviso gives an overarching power to the court where compoundable offenses, including compoundable matrimonial offenses, can be referred to compulsory mediation by the court. So Section 7 has that power given to the court to refer the parties to mediation. Most importantly, subsection 2 of Section 7 of the Act gives a power to the court to make interim measures. So like Section 7 of the Arbitration Act, which provides for interim measures before, during, and after arbitration. Even mediation has this particular concept. So what happens is that the mediation and judicial protection can operate simultaneously. So in a given case, court can make an interim order and direct parties to mediation. So section 8 and 9 deal with appointment of mediators. Parties can mutually agree on a mediator, or a mediator can be appointed through a mediation service provider. A mediation service provider under section 40 can be a body or organization providing for conduct of mediation, which is recognized by the Mediation Council of India to be established under section 31, or it can be an authority constituted under the Legal Services Authority, or it can be a court-annexed mediation center, or any body which can be notified by the central government. Section 10 of the Act provides for disclosure. So then there are replacement, disclosure, all provisions of arbitration scheme has been slightly imported into the Act. Then there is Act provides with the manner in which you have to conduct the mediation. The 3 or 4 broad principles are: there has to be voluntariness, there has to be confidentiality, there needs to be a self-determination, objectivity, and fairness. The role of the mediator broadly is that the mediator is merely a facilitator and not a judge or an arbitrator. Then section 18 provides for a time limit of 120 days, which is extendable by another 60 days. So this ensures that a mediation doesn't remain pending for an indefinite period of time. The emphasis thus is on speed and finality without sacrificing the consensual resolution. Since confidentiality is the heart of mediation, section 22 and 23 ensure that there is adequate confidentiality and people do open up for proposals out, and they don't have to fear that if particular thing is disclosed, then that gets recorded and finally used in the ultimate litigation that may happen between the parties. Section 25 now deals with the cost of mediation, and this may be of some interest to those who are looking at making careers in mediation. So there will be arbitration, like arbitration fees, and as Justice Dangre mentioned, there will be now fees of mediation which will be prescribed under the rules. Chapter 6 is, I think, the most important and a different concept that is going to come up under the Act, which provides for enforcement of a mediated settlement agreement, MSA. So once the mediation is successful, now you can reduce to writing the settlement in the form of MSA. MSA is made enforceable as if it is a court, it is a decree of a civil court. Section 20 provides for registration of MSA under the enumerated with the enumerated authorities. So mediation now is no longer a mere formal compromise executed between the parties, and the statute tends to give a final legal finality and enforceability to the mediation process. Chapter 7 deals with online mediation and promotes online mediation to the extent possible. Section 28 deals with challenges to the MSA, but the challenges, unlike Arbitration Act, is on an extremely limited ground, and this again can be a topic for a debate, because now under the Act the challenges would only be on grounds of fraud, corruption, impersonation, or on the ground that the matter itself was not capable of being mediated. So the legislative policy is thus clear that once a party is once the dispute is voluntarily settled, the settlement should achieve finality and should not become a subject matter of litigation between the parties. Chapter 10 of the Act introduces an altogether different environment for resolution of disputes affecting peace, tranquility, and harmony amongst the community, as it provides for a community mediation. Community mediators can be respected. There need to be a panel of 3 community mediators chosen from respectable persons in the community, or persons recognized for contribution of society, or representatives of the resident or area associations, or even persons having experience of mediation. The object of providing community mediation is not merely an adjudication of rights, but restoration of social harmony and peaceful coexistence. So this is the broad framework of the 2023 Mediation Act. Of course, there is a catch. The act is not notified. Only a part of it is notified. And we are all awaiting notification of the whole act, possibly as arbitration council is yet to be established. Even the Indian Mediation Council is yet to be established, and which is possibly the reason why. Or maybe the government is checking whether the Mediation Act in the form as it is in past will serve the purpose or not. Whatever may be the reason, I think there is an urgent need for notification of the act as early as possible. I often say this, that there can be no better mediator than a judge, especially a judge of the High Court or the judge of the Supreme Court, higher courts, because moment a suggestion is given by the judge, a particular figure is indicated by the judge, parties start revolving around that figures. Unfortunately, that doesn't happen in front of mediators, because we often see that mediation is referred to and we only get a failure report. So I think this should change, and maybe the mediator never has the authority because the parties have fear in their mind that if the suggestion given by the judge is not accepted, then the outcome can be different. But unfortunately, judges also don't have time to devote. We also adjourn the matter for a couple of times, and then finally we say that, all right, I'll render a judgment. Nothing is working out here. But yes, I do understand matrimonial disputes, rent act disputes, labor disputes. There is a great possibility of settlement. So I'm of the view that mediation should not be explored only after the positions are hardened and the costs are escalated, because by the time the litigation lands in the High Court, parties are also frustrated and they finally agree to settle. This usually happens in rent act matters or in labor disputes, even in matrimonial matters. So the Mediation Act represents a shift from adversarial justice towards participatory justice, from adjudication to resolution. Now that a broad and a robust mediation ecosystem is being created through the Act, I hope and trust that the parties to the dispute come out of their traditional goal of securing a victory over the opponent. You might know the place from where I come from. Going to court is considered as a matter of pride. I come from Pune, by the way. So, or in Konkan, you must be aware ki tula courtat khitsin. So more than actually resolution of the disputes is in olden days, people used to have and they used to say very proud, today I'm busy because courtachi tarikh hai. So they have a whole schedule made out. So I think this should be avoided. Courts are not a very welcome place. Try to settle the matters as much as possible. And I again congratulate Avi for organizing this intensive workshop for everyone who's present there. Now I hand over to Mr. Godbole.
Thank you, Lord Justice Marne. I had a huge tension as to how I will face this, but yesterday he cleared my tension and said that you can say whatever you want without looking at me. Picking the thread with Justice Marne said that the higher judiciary is the best mediator. I'll share one of my experiences. There was a matrimonial litigation, property disputes were involved. There was some allegations or factually adultery issues were there. I was a mediator. I tried on 3-4 different sessions, but ultimately it failed. I gave a failure report. The matter was listed before a judge of High Court, and my report was a one-page report that it has failed without indicating what has transpired. The judge asked that what did Mr. Godbole suggest? So then the parties informed that this is what Mr. Godbole suggested. Then the judge said that there couldn't have been a better solution. Why don't you settle? And the matter got settled there. So what Justice Marne says is right. The higher judiciary is the best mediator. Now, another aspect, of course, Justice Marne has indicated, given you the broad overview of the matter, so I don't wish to repeat. But however, I need to first start that for the legal fraternity, we should not look at this enactment as, as an enactment which will affect your practice, work and revenue. There have been similar apprehensions about Family Courts Act, Consumer Protection Act, Real Estate Regulation and Development, which we all call RERA. But the experience has shown that instead of the litigation work or the practice getting decreased, the practice has enhanced, only it has now become a niche practice. Like NCLT has now become a niche practice, family code also has become a niche practice. So we shouldn't have any apprehension that because of this Mediation Act, my revenue or my work or as a fraternity our work will suffer. That's not going to happen. You can always have expertise in mediation, and that's one of the topics I would. Now, it's well known, and I look at this Mediation Act as a very positive step forward, of course, driven by various judgments of Supreme Court like Salem Bar, AFCONS, etc., that the Parliament has ultimately enacted this act and it is notified. As Justice Marne said that unfortunately after 3 years, the many provisions of the act are not yet notified, and fortunately Mr. Anil Singh Learned AG has just entered, so he can now communicate to the government that this is the view of everybody, that you need to notify the provisions of the act. Otherwise, it's a toothless tiger. It's just on paper today. Nothing can be done. Now, this is also voiced in a recent judgment of Judge of our High Court Justice Rajesh Patil in the case of famous Hiremat versus Kalyani, where this has been voiced that today the act is not notified. So there is no question of any mediation being suggested, or because Section 7 empowers the court to send the parties to mediation. Thereafter, it's a voluntary process. But otherwise, the judge can always insist that the parties should first try mediation. I hope, since Mr. Singh has walked in at a apt moment, he would communicate this. Now, Mediation Act, we feel, is why a good way forward. The most historical mediation, or mythological, if one can say, is a failed mediation by Lord Krishna, who couldn't mediate between Kauravas and Pandavas, and which led to Kurukshetra. Fortunately, in India, modern India, now the number of cases which are supposed to have been solved in the National Service Legal Authority Conference, the central government said that more than 861,000 cases were solved by informal mediation, though not statutory. Now, mediation in India, as Justice Marne says, apart from, there are many acts where there are scattered provisions relating to conciliation and mediation, like Consumer Protection Act provides for this, 442 of the Companies Act provides for this, then Commercial Courts Act provides under 12A. I have something to say on 12A. 69 of Civil Procedure Code, and which has been considered by AFCONS and Salem Bar, etc. Now, Section 55 is one section which provides that the Act, once all these provisions are notified, will have an overriding effect on the mediation and conciliation proceedings or provisions in several enactments which are mentioned in Sections 58 to 65. And various provisions of those enactments are amended, in the schedules are there. So that is one thing which, as a legal fraternity, we will have to bear in mind, that once the act is notified, then there would be corresponding amendments, because this is a legislative tool which is employed in many cases. A schedule is provided, and that schedule makes amendments to various enactments, like Commercial Courts Act. We have Apartment Ownership Act, which provides for amendments. So for the legal fraternity, this is one aspect which is required to be borne in mind. Now, dispute resolution, we always had historically pancha committees for communities, then in villages there used to be panchas, etc. But it did not have a statutory recognition and a mechanism which can enforce the result or the outcome of mediation. There was no formal mediation, settlement agreement, etc. Now the Act gives opens a window and makes provision for all these mediation, what is the procedure, what would be the obligations of the mediator, confidentiality, voluntariness, etc. And there is one important chapter which is added, that is community mediation, which is for ensuring that disputes between communities, maybe at a local level, at a particular based on caste and creed, etc., can be resolved through a community resolution or mediation, which concept was not known, but now it is legislatively sought to be brought in. Now, as far as mediation is concerned, as indicated, very few provisions, that is section 1 has been notified, section 3, which is the definition section, has been notified. Then section 31 to 38 regarding the establishment and incorporation of Mediation Council of India is notified. And 45 to 47 relating to mediation fund, and 52 to 54 relating to power of central government and the mediation council to frame rules and regulations have been notified. But the urgent need, if the very purpose of the act is to be achieved, is to notify other provisions, establish, constitute the mediation council, constitute the mediation fund, provide for mediation service providers, make appointments, extensive training of the legal fraternity in mediation. We have very able tenors like Judge Jaiswal, which we heard just now. There are many retired and even serving High Court judges who are expert mediators. As it said that a sitting judge is the best mediator because he can enforce, in the sense not enforce in the manner of passing adverse orders, but he commands that kind of respect. And there is always a lurking fear at the back of the mind of the litigant that in case I don't accept a reasonable solution or suggestion, then I may suffer an adverse order, which is also there in the mind of the advocates who don't disclose that there is such a fear, but the fear is always there. And everybody is aware about that. Now, the Act has addressed various gaps, various defects, because, and I would just indicate very broadly. Now, the term mediation has been defined, but section 5 is not yet notified. So we have that gap which is needed to be filled up immediately. Section 16 is yet to be notified, but whenever it is notified, it preserves the principle of voluntariness in mediation. Now, one important aspect which needs to be noted, I believe Justice Dangre indicated that mandatory pre-litigation mediation should be considered. That, according to me, may not be possible because clause 6 of the bill, mediation bill, had made such a provision that, like section 12A of the Commercial Courts Act, there should be mandatory pre-litigation mediation. But the parliamentary committee suggested that no, this can't be kept because that, according to me also rightly, because it eliminates the very foundation of the concept of mediation, that it has to be party driven and it has to be voluntary. The moment you make it mandatory pre-litigation, then the concept of party driven and voluntariness both will be eliminated. Probably for that reason the parliament felt that similar provision shouldn't be there. Our experience as advocates is that 12A of the Commercial Courts Act has not been effective. Many times it is being used only as a tool to prolong the litigation rather than curtailing the litigation. I don't have the exact data, honorable judges would know, but my experience, whatever little experience I have in commercial disputes, is that 12A doesn't really bear any fruits. The pre-litigation mediation hardly bears any fruits. So probably for that reason, the Parliament probably felt that clause 6 shouldn't be converted into a section and that pre-litigation mediation has been eliminated. As Justice Marne said, however, that does not take away the power of the court under section 7. So it's a limited mandatory reference to mediation, in the sense that the judge does not need the consent of parties for being referred to mediation. Thereafter, however, it remains a voluntary exercise and the parties can decide whether they want to arrive at a solution or not. At the same time, fortunately, subsection 2 preserves the power of the court to ensure that some immediate interim protection, which is required, otherwise the mediation also may fail if that protection is not given. In fact, such protection at times may promote mediation so that the parties know that this is a fetter or this will be a adversity as an interim measure which I would feel or I would suffer. Now, as far as the mediation agreement is concerned, that has been given a very wide scope and ambit, wider than an arbitration agreement. One thing all our legal fraternity must bear in mind, that a statement in pleadings which goes untraversed about mediation is supposed to be now constituted, deemed to be a mediation agreement. So, of course, advocates would take care, but sometimes we tend to miss out. So that is one from the other side that what advocates can consider. Now, as far as mediation agreement is concerned, there is a provision for registration, but the registration is not compulsory. Now, I feel that because suppose mediation is not done, registration is not done, there are instances where the route of arbitration and a consent award of arbitration, which is all decided earlier, is employed by advocates or parties in many cases to avoid many rigors of law, particularly fiscal statutes. So that is one thing which may have to be considered. The registration, at least in respect of matters where property rights are involved, may have to be considered. That, of course, should attract the attention. This is one topic for discussion which all of us can apply our mind, because otherwise it will give more and more litigation will crop up under the Stamp Act, in taxation laws, etc. So that is one aspect. As far as enforcement is concerned, now fortunately section 27 provides for enforcement, so that the parties who go for mediation, earlier there is always a fear or always a feeling that why should I go for mediation, what is going to happen? I will spend 4 sittings, the advocate will spend time. The tendency of the parties is, why would they pay the advocate for attending the mediation meeting? Most of the mediation in High Court is pro bono. So that 27 is now a good step forward. 28 is giving very limited scope of challenge. According to me, what is missing is that a mediation award which is opposed to public policy of India. That is very important aspect which is there in section 34, is missing in section 28. That also should attract the attention of the this entire people dealing with legal issues. The next is confidentiality. Now, confidentiality is there contained in section 22, 23, etc., that you can't disclose what are the suggestions, counter suggestions, offers, counter offers given in the mediation. This will also ensure that now parties will be free to negotiate during mediation. That is something which is a good step forward. Now, as far as exclusionary clause is concerned, if you see the schedule, there are many acts or many provisions under which the mediation has been excluded, particularly in respect of disputes relating to professional misconduct of professionals like advocates, doctors, chartered accountants, etc. My personal view is that all these acts provide for statutory bodies like Bar Council of India, Medical Council, Indian Medical Council, etc., Chartered Accountants Institution. I feel that in many of these cases, the commencement of litigation is driven by some vendetta, or many times the rivalry between professionals also is a factor which initiates this type of litigation. So the lawmakers can consider that if there are all these bodies which are statutory and having peer expertise and peer review can be possible, they should have first step of mediation, and only if mediation fails, then thereafter the disciplinary proceedings, etc., can be considered. Now, one important thing which needs to be done is appointment of mediation service provider. Now, a mediation service provider is a new concept which has been brought in. I feel it opens a new avenue or new scope for practice for the legal fraternity also, because nobody can be a better mediator than advocates, of course, after judges, as I said. And therefore, that's a new avenue which is possible. There are full-fledged chambers in United States of America, Singapore, many Western countries that they deal only in mediation, and they all have a thriving practice. So it's not that only litigation or conveyancing can lead to a good practice. Mediation is also good practice. You don't have to wait in courts. The stress will be less. And this is one aspect which has to be considered. So the mediation service provider, it is necessary that, because the mediation service providers have to be accredited to and accepted by the mediation council or the courts. So the courts can consider, the advocates can consider this as a new avenue. Second is the community mediation, which I have already touched upon. That community mediation also can be assisted by advocates, because the community doesn't know what are the legal provisions, what are the pitfalls in their particular case or stand which they are taking. So there also the legal fraternity can, of course, play a lot of role, important role. This act now introduces a very important aspect of online mediation. Now, online mediation is good. It saves time, it saves transportation costs, it facilitates the ease, because you can do it from your office, etc. At the same time, according to me, considering that the mediation agreement is now supposed to be a decree of the court, it is necessary that in the rules or the regulations which are framed, there are very important safeguards which should be built in online mediation. The reason is that the technology is moving so fast that it is impossible for us what can happen. In an online mediation, therefore, the safeguards which can be considered is that at least the mediator has to attend the mediation through a server or through a server which is controlled, or an instrument where he sits in the mediation center in a district court or a civil court, or an accredited mediation center where this safety in online mediation can be provided. You can imagine, I was just thinking that with the advent of AI, you can create the face of any person, the voice of any person can be copied, his mannerism, everything can be copied, including the background of his office can be copied. So this risk is one aspect which should attract the attention of the regulators, lawmakers, and for that our fraternity can make suggestions and also ensure that the lawmakers have a look at this aspect. As far as the amendments to other enactments, I have already indicated that the act is given overriding effect. Several other enactments would be amended. So once the act is notified, it is obvious that several enactments should be amended. Now, as far as mediation framework is concerned, I have one or two thoughts to discuss with you and suggestions. That, see, our Indian society, that even persons from our families as advocates, they are not trained, they hardly know any provisions of law, though there is sometimes a discussion, etc. The social awareness or the social reality is that almost 80 or 85% of the people in this country are not aware of nuances and fine problems of law. Therefore, when it comes to mediation, apart from safeguards which have to be there in online mediation, one will also need to provide that the mediation is duly controlled. There are assistance provided for parties. Apart from advocates, there can be some sort of assistance which is provided. I was hearing whether a mediator should be provided some, at least the brief. According to me, the mediator should be provided the brief, otherwise the first meeting will go when every party will start arguing as if it's a litigation. One suggestion is that even a foreign national is allowed to be a mediator under Section 8. I think this is something which is a bit risky, because in case of misconduct, which may result in either a civil action or even a criminal action under criminal laws, our Indian courts will have absolutely no control as far as a foreign mediator is concerned. So that is one aspect which has to be considered. The next suggestion is that the government has made it open for mediation only in commercial contracts. Now, my experience is that the government and statutory bodies are the biggest creators of litigation. Their arbitrariness, their fear or lack of fear of law, no government or authority likes courts. That's the only thing which they fear, more of High Court, not of subordinate court as much. And therefore, this is something which the government will have to, apart from commercial contracts, expand the scope of the mediation, where mediation should be provided. Now, the last aspect is that the fee guidelines, of course, would be framed. We hope that the fees are commensurate with the efforts which are made by the advocates. Once this ecosystem is there, then we as legal fraternity should look at it as an opportunity rather than a threat to our practice. All this is possible. All of us, particularly the legal fraternity, should look at this as an opportunity, opening a new vista, a new window for all of us to expertise. Everybody can't come to court. We will be saving a lot of time. And my personal view is that when there is a mediation and a successful mediation, it actually results in promotes the parties to try to come to advocates so that a mediation would be successful, rather than keeping brooding or then approaching police and filing false complaints, which are essentially of a civil nature. So I would suggest that this is a good step forward. The only thing is now it is needed to be notified immediately. The provisions have to be brought in immediately. Okay. That's the only thing I think got an opportunity.
They have negotiated a time with us.
Yes.
And there is a difference between negotiation and mediation. Negotiation is where parties get emotional for money, and mediation is where parties get money after becoming emotional.
So the timeline I have kept perfectly 1 minute early.
There's one more thing.
Thank you so much, sir.
I shared this with my son yesterday, that it's not that mediation is held every time to resolve a dispute. There is one instance where mediation was required to be held to start a dispute. This is where the Walt Disney had to call a mediator because Tom and Jerry refused to fight. Thank you.
Thank you so much, sir.